I'll run through some slides. I hope you forgive me. So first, I want to thank Richard, Adam, and Bo for organizing this event and being so kind as to invite me. I'm really thrilled to be here. And I want to give some special thanks to Kirti Gupta for encouraging this project. We've talked about it for a long, long time, and I might not have started it or even completed it without her encouragement. So thanks very much, Kirti. Much appreciated. Well, to summarize how I got started, the US patent system faces what might be called a perfect storm of criticism. The courts, the Congress, the executive branch, corporations, lobbyists, the press, and most of all, maybe academics are always criticizing the patent system, and it's in a crisis. Here's the Electronic Frontier Foundation. Big pharma is abusing patents. It's hurting Americans, as a recent CNN article, and so on. What I wanted to do was not simply to defend the patent system, because then the critics set the agenda, but what I had in mind was really to make the case for patents. In other words, to argue why it's so important, and really to argue that we should, in fact, strengthen intellectual property rights. And I hope that in some small way, this book contributes a little bit to the discussion and maybe gets rid of some of the most outrageous criticisms. May not, but at least we'll start the discussion. As you can see reading the book, I have a lot of influences, and I want to give particular thanks to Richard Epstein's work. We co-authored, but his work has been an inspiration. F. Scott Keefe, Mark Shankerman, Robert Merges, Paul Heel, and Stuart Graham have been a great influence on this book. And also, as you read the book, you will see echoes of Harold Demsetz, Ronald Coase, who I had the good fortune to talk about related matters for some time, and finally Friedrich Hayek. You'll see these influences throughout. Many others, including present company, have influenced me, but I wanted to highlight those. The book has 5 chapters, and I've coined some terms that you will see in passing. If you haven't seen them before, the market for innovative control, I'm going to talk about that first. Patents versus prizes. I'm going to talk about the business revolution, which is, I think, my term, reasonable royalty damages, and finally, intellectual contract, which I'm introducing here. To summarize the main argument, here it is. Patents are not, as sometimes people say, rewards at the end of a race, the patent race, and so on. They're really just the beginning. I want to make that case, that patents are just the beginning, not the end. In chapter 1, I talk about patents as whether by design or just fortuitously, they have just what we need for efficient transactions and even for competition in the market for intellectual property. They provide exclusion and transferability. This I think we know well, all of us know that, and that's a basis for market exchange. You can exclude others from access, but then you can transfer through licenses or sale. But patents do a few other things less well known. We often hear about disclosure, but usually disclosures in the context of helping others understand the technology. But disclosure of the technology also helps reduce the costs of search for those who wish to obtain the technology. It can mitigate the costs of negotiation and contracting for the intellectual property. So the disclosure function, which is the information contained in the patent, has a transaction cost effect. Similarly to those points, certification by the USPTO helps reduce asymmetric information in the marketplace. We know that the patent has been granted by the USPTO, and that reduces asymmetric information in the marketplace, something like the Good Housekeeping seal of approval. It helps with standardization. I'm not talking about technology standards just yet. What I'm talking about is the patent itself is standardized. If any patent you look at has a similar structure, it has the name of the inventors and the assignment and the claims and drawings and so on. So there's a standardization of the thing itself, which I think may reduce contracting costs. And finally, the patent is a single unit, and this gives you divisibility. You can put them together in portfolios, you can put them together through contracts or just assemble them if you're a user. And this helps, I think, in promoting modularity of inventions, helps with firms that are less vertically integrated, and has helped, I think, promote open innovation, the transfer of your technology to others or obtaining others' technology. We see patents continuing to grow in terms of application. Here's 3.2 million patents worldwide filed in 2019. And patents granted worldwide reached about 1.5 million in 2019. And we see the continued growth of patents that are granted. We see the spread of patents around the world. Here we have offices in Asia receiving more patent applications. And here we see 3.1 million patents in force in the US as of 2019, according to the World Intellectual Property Organization. And we see also the mix of resident and non-resident applicants. And I think this is particularly important. This graph is kind of funny, but it makes an important point. We see the origins of the filers on the left and the patent offices on the right. And we see some indication of the flow of different origins to different patent offices. This provides an indication of the worldwide market for technology, and patents helping with that. In addition to making transactions in the market for technology more efficient, patents support what I have called the market for innovative control. I stole this term from the market for corporate control, which is a term coined by Henry Manny. And the idea is this, that owning a patent has two things, just like owning a share of stock. It gives you residual returns from the ownership, but it also gives you residual control over how the patented technology will be used. Just like a stock gives you both returns from ownership of the stock and corporate control. And the ability to control how it's used in the future will promote more efficiency in investment, in invention, innovation, and commercialization. This is my notion that the patent is just the beginning. Why do I say that? Well, patents then allow own use, protects own use of the technology, allows the owner to license to others or assign the patent to others. It can improve invention as you protect future developments of the patent, of the technology that you've patented, or even as you develop innovations based on the patent, or as others develop inventions and innovation based on the patent. Patents can be part of future business deals. Cross-licensing, of course, can be bundled with know-how or bundled with products. They can be part of R&D joint ventures or even patent pools. In addition, patents promote entrepreneurship as well as finance, whether it's finance of the startup or a new entrant, an entrepreneurial firm, or even corporations. So it's used to develop startups, new firms. It's used for venture capital. Patents support loans by acting as collateral. And finally, they serve as intangible assets. To give you some idea how important that is, you can look at the US GDP numbers, and US investment in intangible assets now exceeds $1 trillion per year in the GDP numbers, and there's a capitalized value of about 6 trillion for intangible assets. This has changed the nature of the firm. About 45 years ago or so, intangibles represented about 15% of the value of the S&P 500 companies, with the rest being tangible assets. In other words, plant, equipment, land, and so on. Today, that has flipped around. Intangible assets are about 85% of the value of the S&P 500 companies, And the intangible assets include, of course, patents and other intellectual property. Different companies have come to the fore, of course, but that's not enough to explain this. It's that the companies on average or overall now constitute at least 85% of value as intangibles. And this is growing. There's studies suggesting that in the last couple of years, that number has grown even larger, approaching 90%. I'm not going to talk about this that much today, but I'm continuing to work on technology standards. Patents are very important because they're fundamental to the formation of technology standards. And in fact, standard essential patents, SEPs, represent the technologies that support standards development organizations. In other words, the standards wouldn't exist without the underlying technologies, and patents are providing intellectual property rights that protect those underlying technologies. Here's a chart showing the development of 2G, 3G, 4G, and 5G patents on the screen. Tim Pullman prepared this chart. Patents also, and this I think less emphasized in discussions, not only are they useful for follow-on invention and follow-on innovation, but patents promote the adoption and diffusion of technology. This is technological change at the end of the line. This chart shows the accelerating adoption or diffusion of technology. In fact, you'll see it starts with the electric grid and radio and so on. And as we get closer to the present, we have the mobile phone, the internet, social media, and smartphone. And we see faster and faster adoption. And this, I believe, is helped by patents facilitating transactions in the market for technology, allowing for faster and faster adoption by individual consumers and firms, and then diffusion. That means going throughout the population. Here we see, for example, adoption and diffusion of Internet of Things. Just now in 2020, there were 12 billion Internet of Things connections, more than non-Internet of Things connections. And so we see the patenting supporting the proliferation or diffusion of the Internet of Things. Here we see adoption, diffusion of mobile broadband, and this picture shows you mobile broadband subscriptions per 100 inhabitants. Of course, it can exceed 100%. You'll see that, say, for Japan with about 170 subscriptions per 100 inhabitants, because people have multiple broadband subscriptions, right? All right, so that's the first step. And the second step is patents playing such an important role in the market for technology, but many have argued that we should get rid of patents. And even worse, some argue that we could replace patents with government prizes. I think that would be worse than no patents, is to replace them with prizes offered by the government. Now, this is not an idle thought, but rather Ben Rowan, in his article in 2014 in the University of Chicago Law Review, tells us that the notion that we could get rid of patents and replace them with government prizes is a consensus among academics, both in law and economics, and notes that there's been an explosion of research there. And so many people apparently, since it's a consensus, believe that we could get rid of the patent system and replace it with government prizes. The argument is based on the following. They say that patents create a deadweight welfare loss. So first they say patents generate an economic monopoly. Patents are priced at a per unit of output royalty. The per unit of output royalty raises unit costs of firms above their actual unit cost, and that in itself generates deadweight welfare loss. This argument is the basis for the prize discussion. It's repeated in almost every prize article. I'm going to explain to you very briefly, it's a long story, but very briefly why this is completely ridiculous and wrong. Patent royalties generally don't cause deadweight welfare loss. Why? Because they're not monopolies. They don't create entry barriers in the marketplace. Anyone can enter the market. It's just, as we all know, exclusive access to the intellectual property. There's plenty of competition. Inventions have substitutes. And finally, royalties come in many different contractual forms. And in fact, they need not be per unit of output and usually are not. They're often all kinds of revenue, profit sharing, fixed fees, and so on, not per unit of output. What's amazing in the literature on prizes is that most of them assume that the money the government will get to pay for these prizes is either free, which is an amazing thing for economists, assuming free money. And then many of them assume if it's not free, it's not distortionary. In other words, the argument goes like this: patents are distortionary because you have to pay for the license, but government money and taxes, in other words, are not distortionary and therefore don't create any deadweight welfare laws. Of course, that's not true. Government taxes, whether on labor or corporations, whatever you want, are distortionary. They do affect behavior and shouldn't be viewed as a source of money. The notion of the prize, this idea is that the government offers a prize and gets the patented technology, and then the government distributes the technology. Well, public ownership has been tried. Before the Bayh-Dole Act, very few of the patents owned by the US government were commercialized. After Bayh-Dole, universities commercialized, creating many new products and lots of new firms based on those technology. We also tried that experiment in the Soviet Union, where there was minimal invention or innovation. The government took control of the technology, but it gave you a medal. Here's an actual picture of the medal you would get in the Soviet Union. That doesn't mean I'm opposed to prizes. Nothing like a nice prize, like the X Prize or the Nobel Prize. I'm not opposed to prizes. But there are very few prizes out there. Even when the government gives prizes, they give very few, and private prizes are few and far between. So it can't replace. Imagine replacing the US stock market with prizes for investment. It wouldn't generate much investment. And the same thing is with government offering prizes for technology, wouldn't generate very much. All right, time is running short. I'm going to go a little bit faster and jump to chapter 3. Chapter 3 talks about patents and what I call the business revolution. By this, I mean AI and e-commerce and other technological developments that have replaced human effort in economic transactions, just as, say, the Industrial Revolution replaced human effort in manufacturing. And this is referring to advances in information and communications technology, or in patent terminology, business method inventions. Often this involves commercial inventions as distinguished from traditional scientific or technical inventions. And these can also bring scientific and technological inventions to the market that are complementary as part of the patented technology. The idea of this discussion is that it's kind of a backdoor way of limiting patent intellectual property rights, particularly patents. And so there are various cases: Bilski versus Capos, Mayo v. Prometheus, or Alice versus CLS Bank. And these are subject matter eligibility requirements that try to, in my view, treat patented technologies differently based on the industry. Of course, we don't want to give patents for laws of nature or things that are obvious, but I worry that subject matter eligibility requirements can weaken the patent system by limiting what you can patent. In particular, in Bilski v. Capos, the case asked, should we eliminate business method inventions entirely? That wasn't the conclusion of the case. It was just a question that was posed in the case, and this inspired me to worry about it. And so I would be very careful, and my argument is don't impose subject matter eligibility requirements simply as a way of weakening the patent system. Fourth, I talk about patent infringement and reasonable royalty damages, and the arguments for reasonable royalty damages are often based on protection of intellectual property rights, which is great. But as you get inside the cases, they talk about something called the hypothetical negotiation. And that is, what would a willing buyer, willing seller have negotiated before the infringement occurred? And often, in my view, this means we turn back the clock to what would have happened had they actually, had the infringer actually gotten together with the patent holder. My suggestion is in some ways, I hope, a modest one, and that is that we don't throw out all the information that happened since the infringement. And so I suggest that contracts can be a clue. The patent license agreement is in fact a contract. And so had there been a willing buyer, willing seller, they would have formed a contract. But we should see what happened with infringement since the time of the infringement. How was it used, and did they make money, and so on. And this could be used to use more of the information from the case in compensating the patent holder and calculating reasonable royalty damages. In other words, this can be helpful, particularly if we look for comparable patent license agreements. The other thing is that I suggest here that if we can't find comparable patent license agreements, we may be able to get additional information from market transfers of patents. In other words, the sale of the patents gives us a clue about the present value of royalties, even if we don't have comparable patent license agreements. So the market value of patents may provide information that could be used in inferring reasonable royalty damages. Finally, I conclude talking a little bit more about contracts. The patent license agreement is what I call an intellectual contract. Intellectual property is the patent itself, but intellectual contract of one kind or another is what's needed for commercialization of the patented invention. So I have in mind a broad set of intellectual contracts: employment contracts, which are principal agent contracts, outsourcing R&D and other technology contracts, also principal agent type contracts. People have written about these. Joint venture and consortium contracts involving R&D. These are the problems of moral hazards in teams. And license contracts, of course, patent license agreements, which involve negotiation at their formation, and what I call platform contracts, two-sided or multi-sided markets for technology. This could be technology market intermediaries, which call themselves sometimes patent pools, and then actual patent pools as well. And so we see that the patent is the beginning, as I like to say, and here is something that follows is intellectual contracts, which are based on the underlying intellectual property. So the intellectual contracts is important for the creation and transfer of intangible assets. It recognizes that technology may involve non-rivalrous usage of the underlying intellectual property, and intellectual contracts are becoming more and more important for technological change. And so I'm suggesting more attention by people who know more about contracts to the formation of intellectual contracts. The most important thing I want to end on this for patent license agreements is that they are indeed negotiated. Since they're contracts, they will last a while. They are tailored to the needs of the licensee and the licensor. And therefore, negotiation of patent license agreements gives you particular properties of the economic transactions. These properties, which I can elaborate on if you want later, eliminate many of the antitrust concerns about patents. In other words, with a negotiated patent license agreement, you will not observe all these this parade of horribles that people have alleged. It eliminates the problem of royalty stacking. It eliminates the problem of SEP holdup, in which patent holders are said to take advantage of adopters of SEPs. It eliminates patent thickets, blocking patents, and the tragedy of the anti-commons, which are all pretty much the same, referring to the problem of too many patents. And finally, the negotiation of patent license agreements eliminates the alleged need for patent pools as a means of regulation of patent license agreements. So I'm not saying I'm opposed to patent pools, on the contrary, but it tells you that patent pools are useful for reducing transaction costs in the market for technology. That is true. So where you can reduce transaction costs with a patent pool for about 10% of patents, say. But you should not encourage patent pools as a way of reducing royalties, because they don't. And in fact, what's interesting about patent pools is that they tend to give participants the option of going outside the pool to negotiate bilaterally, so that the bilateral negotiation of patent license agreements provide, even if it doesn't happen, provides a check on the royalties of the patent pool itself. So it's really, the regulation comes from the option of the patent license agreement that limits what patent pools can charge. And so it's important. And you'll see this at, say, Avanci has this option, and you will see this for other patent pools. I explained this at greater length in a recent paper that just came out at the Minnesota Journal of Law, Science, and Technology, so I'll stop there. So in conclusion, I think I stayed within the time. I'm going to stop sharing in a second. Patents are the foundation of the market for technology. In particular, they're the foundation of what I call the market for innovative control. I think intellectual property rights, particularly patent, motivate firms to invest in intangible assets, which, as I mentioned, are fundamental for the modern firm. And they're helpful both in invention and innovation, but also the founding of innovative new firms. In other words, the innovative entrepreneur. So in conclusion, it's the benefits of the technological change created by patents and fostered by patents that makes the case for patents. So thank you very much. And sorry to go through all these slides, but I'm going to stop there.
Now, I'm not sure what was more impressive, to write the book or to summarize it in 25 minutes exactly.
Big is to stop.
So, yeah, I would like to welcome our commentators now. We have Paul Heald, we have Stefani Smith, we have Layne-Farrar. And I guess you have your presentation up already, Paul. So whenever you're ready, please, Paul, go ahead.
Okay. Well, let me start by thanking Adam and Richard and Bo for this opportunity to comment on what is truly a terrific book. I'm really honored to have the chance to share some thoughts here. Just in general, you know, it's, to me, this is clearly valuable, sophisticated, and a really comprehensive defense of the patent system. And I want to say one thing about the audience. The audience for this book is clearly, you know, educated lay people, in the sense that you do not need to be an IP professional to understand this book at all. And also, I would say for policymakers too. I wish sophisticated readers and policymakers overlapped more, but clearly this is the audience that I see being addressed in the book. So anything that I say that might even vaguely be construed as a critique is simply because Dan cannot write this book for absolutely everybody and solve every single problem of patent law in it. So I elaborate at points in what I feel is an extremely friendly way to sort of illustrate how valuable I think his framework is. I'll focus on chapters 1 and 4, which interest me the most. I don't really worry much about patents being replaced by a prize system, mostly because our treaty obligations say we have to have a patent system, and we in fact wrote those treaties. But the comparison that he makes is in fact valuable, as I think you'll see in a second. Chapter 3, I think he's already won the business method patent argument, but that chapter does raise some really interesting questions of scope, which I think we'll have time to address. It's chapter 4 on remedies that I find really interesting. And then chapter 5, I think, sort of follows naturally from the insights in chapter 1, which I'll start with. I love this approach to defending patent law as really providing probably indirect incentive to innovation, as opposed to the direct reward theory, which we're used to hearing. And he started with people dreaming of getting a patent, and therefore being stimulated to engage in inventive activity. I much prefer this approach, which I really see as sort of a new institutional economic approach, and it shows in his critique of prize systems. A patent is a reification of information assets, right? Which conveys extremely valuable qualities to this new asset. He mentions transferability as key, disclosure, certification, financing, and the ability to divide the asset and to provide control over commercialization activity that happens afterwards. This is why we need and want to have a patent system, and not because a patent is some sort of substitute for a prize, which is dreamed about by inventors. And I'll illustrate this maybe into sort of 2 points. I'll call them market points, how this sort of plays out in real and valuable ways. The first requires a shout out to Jonathan Barnett, right, who points that patents actually tend to protect smaller firms. If you're a firm with tremendous advertising capability and great human capital and a huge first mover advantage, the only way a smaller firm can compete with you is by outcompeting you in inventiveness. And the fact that patents allow smaller firms to reify and convert into property the information that they've developed is precisely what allows them to compete with larger firms. And it's one reason why, as he explains in his wonderful recent book, that it's often large corporations who are pushing for watering down of the patent system because they want to maintain market dominance. So this is not a story at all about enshrining the power of large corporations in the guise of protecting the patent system, but in fact, it really is a story about markets and transferability. The second, I have a friend who's a Malawian law professor named Chikosa Banda, and he has an unpublished, unfortunately, doctoral dissertation that makes Daniel's point about coordination and control and team production really, really strongly. He's done a study of consortia which arise to address orphan drugs in Africa, right? These are drugs which address very serious diseases, but the people who get them don't have any money to pay for the drug. So there's no economic incentive at all to create a drug to address these diseases. So what you have is consortia of usually several governments, an NGO, a pharmaceutical company, and a nonprofit coming together to address the particular problem. What he found that was extremely interesting is they all patent, right? They have no desire to ever sell the drug, right? They have no profit motive at all in the developing of the drug, and yet they find it extremely useful, right, to organize their team activity around a patent, which allows for control and divisibility of labor. And I wish you'd get this dissertation published because it really profoundly, I think, illustrates the point that Daniel makes in chapter 1. Okay. I said I'd briefly mention chapter 3. I think the argument over business method patents is one, and all the interesting questions revolve around what's the optimal scope of business method patents, what level of novelty to require, what subject matter should be protected, what's the scope of non-obviousness, and we can't expect Daniel to show us precisely what the optimal level of non-obviousness is in testing whether something should be protected by a business method patent or not. It suffices, I think, to prove that they shouldn't be treated any differently than any other sort of patent. And it is, however, a great area of patent law to talk about the problem of what the proper scope is and try to determine what the proper scope is. Clearly, you can have too much protection. If I'm the first person to think about selling lemonade online, do I need to have the exclusive right to be the only person now to sell lemonade online or anything else online? There clearly needs to be some fine tuning about what gets protected in the business method context. And I'd have to say that this is really an empirical question. And I really see the book as laying the framework for sort of step 2, which is empirically testing what the most efficient level of protection is in various contexts, and there are people currently working on that. But I'd like to I hope this is like the last framework book ever written, because it does it all, and it's time for the empiricists, I think, to jump in. Finally, one point related to business method patents, and partially related to software patents, which get junked in with the business method patent question. And that is an area where maybe Daniel, I hope, agrees with some of the critique, and that is the US Patent Office Bulletin Board sucks, right? In order for this approach to patent law, which is focused on transferability, which is focused on improving information, which is focused on contracts and inventors finding people who need inventions, you have to have a better website. You have to make it cheaper and easier for people to find the technology that they want. And right now, way too many people can't find it, self-invent, and then get blindsided by a patent infringement suit later, because the website and actually the whole classification system is really problematic. So a lot of times I think when people attack business methods, that's the sort of thing they're worried about, as opposed to Ben Rohn's fabulously overdrawn notion or his fabulously overdrawn critique. Okay, so moving on to chapter 4, and I suppose chapter 5 to bracket. I love this contractual approach to remedies. I think it's the best way to think about what proper remedies should be. I'll note that the book accepts reasonable royalty as the proper remedy, and this brings up a question of scope. Daniel doesn't suggest we should have the death penalty for a patent infringement. That would deter patent infringement much more strongly than a reasonable royalty remedy, but you wouldn't have a lot of inventive activity going on because people would be too afraid. And in fact, it doesn't even argue that there should be a remedy of an accounting, which would be the ability of the victim of infringement to capture all of the profits made by the infringer. This was a remedy in the U.S. patent system till the early 50s when it was done away with, and he doesn't even push it that far. I think the focus on reasonable royalties is consistent with the contractual approach that he wants to take. I only have 3 slides, but this leads me to slide number 2 here. Let's see, next slide. There we go. All right. No, I'm not going to go through this this algorithm here. What it is, I think, is a way of building on Daniel's insight about taking full account of all information we have about the relationship between the infringer, the infringed, and the invention. And the friendly amendment is that it's probably less valuable to talk about the value of the patent as opposed to the price of the patent, right? So patent is, I think, best analogized to a stock option, right? And how do we don't value stock options. Nobody knows what the value of a stock is going to be a year from now. But because of the Black-Scholes equation, we can in fact price a stock a year from now in such a way that half the time the buyer of the option will be the winner and half the time the seller of the option is going to be the winner. And because we have different risk profiles between buyers and sellers of stock options, we have an incredibly vibrant market for stock options, which did not exist before Black-Scholes math. That's why they won the Nobel Prize. So one of my colleagues has a variation of the Black-Scholes equation where he treats patents as stock options, and you can go through this if you want. It may be right or it may be wrong, but I think the most promising way to think about reasonable royalty damages is through some variation of Black-Scholes mathematics, which is, I think, entirely consistent with the way Daniel is talking about remedies in this particular context. Okay, finally, and since Ronald Coase couldn't be here, I'll step in for him and suggest an overall approach to remedies, which again I see being grounded in Daniel's approach. This I will go through a little bit, and it's based on the Coasean insight that If in fact we're in a world with no transaction costs, we're in a world with completely full information, all we need is a series of enforceable contracts for parties with inventive capacity to negotiate and contract with parties who need inventions, right? And we can actually model what sort of transactions are going to occur in this world without transaction costs. That's the inequality there at the top. And on the left side, what you have essentially is the value of the new invention to the party who needs the invention. So we'll start with VI, which is the gross value of the invention. From that, we have to subtract the lower of the cost of finding the invention, searching for the invention, or self-inventing, which is the other alternative. We subtract the smaller of those two amounts. And then we also have to subtract the value of the known best substitute, right? Because there's almost always some sort of substitute that may not be quite as good, but the overall value is going to be the difference between the new invention and the best known substitute. So the left side in red, we have the value to the firm that needs the invention. And on the right, we'll just have C. This is the cost to the inventing firm of actually inventing the invention, and also potential cost of transferring. And maybe we want to even consider anticipated lost profits if in fact the inventing firm might be able to use the invention itself. In any event, sort of a simple model of what happens in a world without transaction costs. And what you can do is establish a remedial system which incentivizes this exact transaction. The numbers aren't too hard to come up with, and you can construct a remedial system using either an accounting or reasonable royalty or punitive damages, even sometimes depending on what the numbers are, to incentivize precisely this sort of transaction, which we know illustrates our world of optimal inventive activity. So this is the kind of thing we can't expect Daniel to do this in this book, or it would be 10,000 pages long. I provide this as an example only to show you where I think the book leads, where I think this framework leads in the kind of thinking that is usefully inspired by the book, which obviously I think is terrific, and I look forward to everyone else's comments. Congratulations, Daniel.
Thank you. Thank you very much.
Great. Thanks so much, Paul. You just led us along this nice journey, and then you just slapped the math on us there at the end. So now we have to recover a little bit. And thanks for doing the effort. I know Paul's sitting. He had to break into this house where he is to get Wi-Fi in rural Michigan, so he has to get out before they come home. So no, it's not that bad. But thanks for going to the trouble to get to be here today. We really appreciate it. Next up, we'd like to have Stefani Smith. Stefani is a partner at Tensegrity law firm, and before that she was an assistant professor of economics. If she has a little time left over, she can tell us how she was able to escape from academia. Thanks,
Yeah.
Stefani. You're up.
Yeah, thank you so much. And I apologize in advance. I have a little puppy who's running around in the background who hopefully will decide not to bark while I'm speaking. So thank you so much for the opportunity. I echo Paul's gratitude, his appreciation of Dan's fabulous work, and I also echo his caveats. I did hear him say that the case for business method patents is won, and that they shouldn't be treated any differently than any other patents. I guess would that it were the case, but as I'm going to say today, I'm not quite sure that the case has been won beyond a narrow group of people. So as Bo mentioned, in a prior life, I was an academic economist. In my present incarnation, I'm a patent litigator. I'm going to assume that what you're interested in hearing from me today is not about economic theory, but tales from the front. So putting the Mark Lemleys of the world aside, today, the day-to-day of a patent litigator is not about policy. It's about putting on the best possible case for your client within the current rules. Occasionally, as Adam knows, we have an opportunity within the confines of a case to push the law in one direction or another through advocacy, if it makes sense for a particular client on a particular issue. I occasionally take on the task of teaching the law and economic foundations of patents to people around me, and I commend Dan again for those efforts. If I didn't agree with him fundamentally, I wouldn't have the job I have. So I'm going to offer some observations by way of a couple of case studies that I think are highlight the challenges in making the case for business method patents, as Dan has taken on the task. My purpose is to highlight that the resistance to business method patents is not fundamentally about efficiency or even about utilitarian trade-offs. So 2 points. First, I've been behind the scenes in some of the biggest patent litigation cases in the last decade. I was collecting and reading documents. I was interviewing the engineers. I was deposing the inventors. And I can tell you that patent law and licensing is not a place for moralizing about good guys and bad guys. Not only have I seen the sausage being made, but many of the loudest companies speaking against patents are themselves secret investors in the funds that comprise the corporate form for what are called patent trolls. Second, I'm going to give you a couple of war stories today that provide a contrast to the case that Dan makes for the business method patents. I have represented patentees in the business method space that have been and remain poster children for those opposed to business method patents. I think both sides of the discourse about business method patents is not saying aloud, or at least not saying loud enough, what the real issues are. In short, it's a legal standard and a burden of persuasion question. Without addressing those issues, I don't think we can hope to win over opinions on business method patents. So, a tale of two patents. Case one, patent one. We represented Wake Forest University Health Science Hospital. There were two inventors. One was a practicing physician at the charity hospital, and the second was a university materials science engineer. The physician had been seeing patients for decades and seeing certain types of wounds that were killing people. They were open wounds, wounds that would not close to heal, and the patient would eventually die of infection. The physician had an idea. Let's use a plastic cover with an adhesive seal. We'll surround and cover the wound. We'll put a sponge between the raw flesh and the plastic. We'll put a valve into the cover above the sponge, and we'll use negative pressure, suction, to gently pull close the wound. He did successful tests on pigs. He could not get approval for human trials. Every time he attempted to get approval, he was told that he will exsanguinate the patients and he's going to kill them. He filed for a patent application. He presented his findings at medical conferences. His colleagues at the conferences thought he had gone senile, had lost his mind, and told him he was going to kill people. He submitted papers for academic publication. They were declined. He was told he was dangerous. He was told he was going to kill people. He had a patient, a motorcycle crash victim, who had removed large portions of his skin in a horrible accident. He'd been in the hospital for more than a year. He was dying. The hospital review committee said, okay, fine, informed consent, go ahead and do the trial. He walked out of the hospital 4 weeks later. It was nothing short of miraculous. The technology was licensed to a failing hospital bed company in Texas. The inventors, by the way, were non-practicing entities. Every hospital and trauma center uses this technology today. Surgical wounds that won't close, trauma wounds. Army surgeons from the Gulf War report back that the wound vac is the most important medical innovation in a century. It's more important than penicillin. There was patent enforcement against copycats. The biggest one was against a company called Smith & Nephew. The Western District of Texas jury found the patents valid and infringed and awarded large royalty damages. After the verdict, the district court judge granted JMAL of invalidity. He said the jury did not have a sufficient basis to find the patents were valid. The judge believed the patents were obvious. People have been sucking bad stuff out of wounds since the caveman days using animal horns. Saran wrap, adhesive, obvious. The Federal Circuit overturned that JMAL decision. He said the judge applied hindsight, that the court relies on the objective indicia to find that at bottom, it could not possibly have been so obvious and yet so life-changing. If people knew how to do this before, why hadn't they been doing it? Case two, patent two. We represented a company that was a 1990s Silicon Valley startup. They developed a way to monitor online interest in particular products and to make real-time price adjustments to maximize some seller objective. They filed patent applications. My puppy is barking. And they talked to online retailers. Obvious, right? We're economists. Sellers observe market conditions and they price to maximize some objective function. What could be more obvious? Well, let's compare this to the claims in Deere. This is a famous patent eligibility case. In Deere, they did real-time monitoring of temperature to cure rubber. When the temperature is right, according to the Arrhenius equation, wherein curing synthetic rubber depends on time, temperature, and the thickness of the mold, you stop the process when the Arrhenius equation tells you that you have optimal rubber quality. Any economist will tell you that pricing decisions are even harder than engineering. There's no Arrhenius equation that tells you when to stop adjusting the price to achieve optimality. So how could the Deere invention be eligible and the OIP claims of price adjustments be ineligible? While the patent application was being prosecuted, the startup met and pitched the product and the patent to the world's largest online retailer. They did a real-time live trial that overlaid their pricing engine. They demonstrated improved margins on real products in real time by high single-digit percentages, which is huge. The company was made job offers, but they weren't offered a buyout, and so they declined. The patent issued a couple years later. We represented this non-practicing entity plaintiff in a suit against Amazon filed in March of 2012. The CLS Bank v. Alice opinion issued. We lost a motion to dismiss on the grounds of patent ineligibility in September of 2012. The Federal Circuit CLS Bank en banc decision issued in May of 2013, and then the Supreme Court Alice decision issued in April. The Federal Circuit then decided OIP's claims were ineligible under Alice, and our case is gone. OIP remains one of the poster children for the post-Alice patent ineligible business method patents. As Dan thoroughly explains in his book, there's no question that the technology improved the economic performance of Amazon's pricing engine. It was demonstrated. And like the Wake Forest case, it's part of the factual record of that case that the improvements over the prior art showed that it was novel. Those facts were assumed to be true at the motion to dismiss stage of the case. If Amazon couldn't figure out how to do it, who had, and why was it ineligible? There's a deep skepticism about the burden of proof and the accessibility of evidence for business method patents. The Western District Texas judge used hindsight and pointed to cavemen with animal horns and saran wrap to say it was obvious. But the Federal Circuit judge said the proof of the pudding is in the eating, and no one was healing wounds in this way, so it couldn't have been obvious. For OIP's claims, if these claims are patent eligible, how was Amazon to prove that someone had done this before in order to meet their burden of proving invalidity? A shopkeeper selling umbrellas in an open air market adjusts the price upward in response to gathering clouds. Not only does this happen, economists spend a lot of energy telling people that this is natural and good. But how can Amazon prove that it was actually previously in use or actually known, especially on a computer? Are there publications describing every step? Are there prior art apparatuses to show the jury? A patent is presumptively valid, and Amazon can only argue evidence with hindsight and no tangible prior art. Courts and the public are deeply suspicious that if patent methods are patent eligible, it would be difficult to generate evidence to overcome the presumption of validity at trial. So my conclusions are that the skepticism about business method patents is not a skepticism about the pro-market impact of those innovations, as Dan suggests. Instead, it's a fear that the accused infringer will not be able to meet its burden of proof given the unavailability of evidence. A large motivation of the perception of the utilitarian trade-off in patents is embodied in the concept that Dan repeats in the book from Judge Giles Rich. A time-limited exclusive right to subject matter, which was neither known nor obvious from what was known, takes nothing from the public, which it had done before. But with business method patents, we have technologies that may have been trade secrets for millennia, but which are readily reverse engineered or rediscovered, and yet incredibly hard, if not impossible, to prove were in the prior art precisely because they are business secrets.
Very good. Walk to the front lines. I feel a little bloodied. Now, I'd like to introduce Anne Layne-Farrar. Anne, please, you're Vice President, Charles Rivers Associate, and an adjunct professor at Northwestern. Thank you so much for being here today. Please go ahead.
Thank you for having me, and let me be the third to echo that I really enjoyed the book. I'm hoping that you take a boatload of free copies and distribute them on Capitol Hill. I think it might make the world a better place. And so I'm going to just make some random comments throughout the chapters with an emphasis on chapter, I think it's 4 on the patent damages, because that's, what I do. So starting off on the patents and markets, I think you make a very compelling argument here. And one of the things that's been so frustrating to me over the last decade or so is the presumption that there's quote unquote too much litigation. And that's a symptom of some evil being wrought by the patent system because they're all being litigated. But I haven't seen any empirical metric by which to establish that point. What exactly is the optimal level of litigation? How do we know when we've exceeded it? How do we know if we are below it? Clearly, with the kinds of rights involved in IPR, which can only be established through enforcement, which often means that at least the threat of litigation, the threat of damages at the end of the road, you're going to always have some level of litigation. And so I think that's yet another hole in this parade of horribles that you're pointing to that has not been established or been firmly refuted yet. In terms of patent scope, I know it's a favorite subject of law scholars, but as an economist who's a practitioner, I often find it to be a distraction. And let me explain why. Yes, we want to get it right. We want to have the proper rights applied for each and every invention, not too strong, not too weak, so that we have the possibility of proper remuneration for an invention, the inventor receiving the value of what he or she has contributed to society. But scope is kind of a malleable concept. It's not the end game. When the USPTO says, here's what's in the claim list, there are a whole lot of other shots at that scope through the PTAB and through courts with claim construction and the markment phase. And you often see what people thought were really broad patents being decimated through claims construction. Because of the tweaking of the words, the scope shrinks a great deal. And that's probably a good thing, right? Because as the market evolves and the use of the patent is seen and where it's being, where those technologies are being applied and where they're not, you want to have some sort of flexibility to adapt with that market. And so I would argue that the patent scope and its evolution over time and the life of the patent is not such a bad thing. And so we shouldn't be too hung up on getting it perfect at the initial stage at the USPTO, for whatever that's worth. Moving on to chapter 3 and the business revolution. I loved all the data and the statistics you had in there. I think you need to do some short pieces for places like Law 360 and other things that like 5 pages where you just slam all that data in there. Make the case for here's what the economy rather looked like back in the 1800s. Here's what it looks like now. These are very different things. Let's not conflate, what invention was and what it is, and our competitiveness with China depends on this. I think you could pull a whole series of policy pieces out of this chapter with the data that would be hugely helpful for the broader debate for policymakers. And so I'm encouraging you and everyone else to pick up that gauntlet. And now to the main meat, the patent damages and infringement in chapter 4. So I certainly agree with the broader point about the hypothetical negotiation really being a fiction and quite difficult for everyone to get their heads around, because clearly you didn't have a willing licensee and a willing licensor because they never licensed. And in fact, even at the time of trial, you may not have a willing licensee and a willing licensor. That being said, in my experience in practice, I think it's not as bad as it looks. And in reality, even under the hypothetical negotiation framework, evidence and data that occur after the point of infringement are always taken into account. And in fact, if you don't, you're likely to face a really bad Daubert decision. So there's this, they do it in a janky way. They say, oh, well, the book of wisdom allows us to have a crystal ball and see everything that occurred after the point of infringement. And so it is a strange way to get it in, but it does get in. And I think that the intellectual concept there is, if we set this hypothetical negotiation to right before the infringement date, then we can be more confident that the royalty damages we calculate are going to be reasonable and not include any kind of switching costs or holdup, which is a fair point, right? So you want to abstract from that. You want to capture the value instead of using the technology. And here, Paul, I'm going to disagree with you a little on this price versus value. Yeah, it'd be boring if I didn't, right? Because I think value gets you closer to being reasonable. And the reason I say that is, think about, for example, patents in the IoT space. You can have the exact same communications technology, say it's embodied in a chip, that's used in a smart vending machine that tells its supplier when it needs new Coca-Cola, in a self-driving tractor, or in a car, right? And so those are really different applications of the exact same technology. You're not going to have a single price for that technology. The value of use of that technology can differ across all of the applications. And that means if you focus instead on the value of the use to the accused infringer, you're going to get closer to the reasonable payout. And of course, across all uses, then the inventor gets the value of the technology to society, because you're capturing little bits here, larger bits there, piecing it together to the overall value. I think that same issue makes it way more difficult to rely on the sale price of patents. In my experience over 25 some years of doing these kinds of cases, there have only been a handful where the patent was sold. So it's not something that comes up as often as you might think. And when it does, they're typically in a portfolio, a large portfolio. Sometimes you have multiple portfolios combined together with a single sale price. And so teasing out what any individual portfolio is valued at can be extremely difficult, let alone any individual patent or handful of patents within that portfolio. And as you point out so rightly in the book, patents are not created equally. There's a distribution. So if you have a portfolio sale, how do you know that the patents you're looking at are really the top value ones, are average, are low value? It can be extremely difficult to tease that out. And in damages cases, the way we usually handle that is the economist works closely with the technical experts, but there's still a ton of subjectivity there. So I think, pulling in patent prices really doesn't get you away from the subjectivity problem. I frankly don't know how to solve that problem. I think the fact that we've been dealing with this for, I don't know how many hundreds of years, and the current mess that damages are in right now sort of illustrates that nobody has the silver bullet. Certainly when patent sales are around, economists pull that information in and use it as a piece of the puzzle, but it's still part of the subjective analysis that damages unfortunately boils down to. But I think, you noted that you thought your proposal was a modest one, and I would say it's actually probably more modest than you think, because I think we're closer in reality to your contract approach and in employing all of this ex post information than you may realize from the ridiculous jury instructions that you might read, and which in my experience, most juries ignore anyway. So on that note, I will end.
All right. Thank you very much, Anne. It was great to get a viewpoint both from an academic perspective and a practitioner perspective. And I know, Anne, you go back and forth in both places. So it's really great to listen to you. All right, we're ahead of schedule. I actually don't know how to handle that. It's never happened to me before. So
I'd like to hear Dan's reactions to
yeah,
what
maybe
we
we
all
get we have,
said.
we have a few minutes now. Let's hear what Dan has to say. Good idea, Aaron. Thank you.
Well, thanks
Please,
very
Dan.
much. And I would like to thank all three discussants for the very kind words and also for the criticisms as well. That was very helpful. And so I on Paul's comments, so the notion that the USPTO doesn't have a good bulletin board or a good website, although Google does have a patent search feature, but I agree that this is an opportunity for business, and the private sector can definitely step in and perhaps should. And I think we're partly there. We have these private patent pools like Avanci and other companies that are heading toward there, and they're specialized firms that help guide inventors or users. But I think that there may be opportunities in the marketplace based on your comments. And the same applies to private transactions that can take advantages of the need for better transactions in the marketplace. And so I very much like the Kosian perspective. I think we share that view. And here again, there are opportunities for the private sector to step up rather than more government intermediation in the market for technology. I really like the two case studies, Stephanie. That was very, very scary and helpful at the same time. I mean, where I started on this issue of the business method is that, you know, speaking of horns being used to suck out wounds, if you read the I don't know if David Cape, I don't see David. There you are, David. You're of course more familiar with Bilski v. Capos than I could ever be, but my goal was to, since you are the Capos, right? So my goal had been to write the first paper on Bilski v. Capos. I think I did. I ran out and wrote this as fast as I could and published it in the Journal of Legal Analysis at the time. And what set me off was the question of the case: should we have them at all? And my first reaction was, you know, it reminds me of, you know, an old Peanuts cartoon in which Lucy says, "I love humanity. It's people I can't stand," right? So it's like that with patents. I love intellectual property, just not patents. And that was the feeling I got from this case. Is, oh, patents are great, just not anything on the cutting edge of technology. Get rid of those. And so what's the cutting edge? It's whatever happens to be the cutting edge at that moment. So, okay, business method patents are hot. The internet is hot. I love all the patents, just not those that are currently important on the edge. So you attack those. And then later on, you attack whatever biotech or whatever is on the cutting edge and say, I'm just objecting to this particular thing, not the other things. Or I like all patents except SCPs. You know, I like anything. Patents are the greatest thing, just not the ones that are used in standards and this kind of thing. And in fact, the case Bilski v. Capos makes the question, should we have any? And to get back to the horn sucking out the wounds, Justice Stevens in that case goes on and on about what's a good patent. And his example is a harness for a horse. That's a good patent. What's a bad patent? Software. Now, why? Because, well, presumably horses were long ago, so it's okay. But right now, the cutting edge is software and computers and e-commerce. So I just object to these, but I like the others. So I had this reaction a little bit when hearing about the case studies. I take your point, Stephanie, about the skepticism about the infringer's burden of proof. But I'm making, I think, just a slightly broader comment. Of course, these are very important legal considerations. I'm just saying, let's not pick on the cutting edge. And to me, business the business, what I call the business revolution. Some have called it the fourth industrial revolution. That's the cutting edge right now, AI and computer related things and, mobile phone related apps and so on. These are the cutting edge. Don't just rule them out, because what that does is it impairs the whole system. But of course, one has to be very considerate of charges against infringers that they can't defend against. I'm with you there, and it has to be a balanced view. I'm making sort of a broad point without many of the legal subtleties, I confess. But I thought your two examples were helpful to me to thinking about this problem more. So there has been some consideration about the too much litigation problem. I mean, Katz-Nelson has a lovely chart in which he shows that the litigation is rare. The studies of litigation are common, but the actual litigation is extremely rare. And in fact, we're talking about 1% or something or less. And in fact, he then goes on to weight it by GDP or by number of patents. And then you see that we're not in a period of high litigation. It's actually fairly low. And so that my answer is that there's some thought about it. I think the point is that people study litigation because there's lots of information. It's like the old thing about looking under the street light because the light is better there. And so I think that there's less reward to showing that there isn't that much litigation, which is my feeling. So I will stop there, but thanks very much. And I agree with you on the Book of Wisdom tends to be forward-looking, but I just wanted to say that I think we should formally acknowledge that we're looking forward. If I had to summarize my idea of the informed contract, maybe we recognize that people do it anyway, but I'm not sure. I leave that to the experts.
See you in
Thank
the
you,
future.
Dan.